Welcome to our Rapid Fire Wednesday Q&A for corporate immigration professionals. I am Kimberley Robidoux, a partner in our San Diego office, and I'm joined today, as always, by Miki Matrician, the co-managing partner of our Boston office. How are you doing today, Miki?
Hi, Kim. I'm okay.
I'm good. So last week, you and I were in Washington, D.C. to participate in the American Immigration Lawyers Association's National Day of Action, otherwise known as NDA, during which we met with congressional representatives and senators in order to discuss immigration in the U.S. And together, we also attended the ALA Spring Conference, which typically is, panels that have national committee members and members of the government that communicate with us and provide updates. So, despite it being a busy week with these events, it was made even busier with updates and changes to a few immigration programs. Those programs include CHNV, which is Cuba, Haiti, Nicaragua, and Venezuela Parole Programs, the Venezuela TPS, F-1 Student Status, and United for Ukraine. USCIS also issued an update to the Form I-9, which was a lot of changes in 1 week. So, Vicki, let's tackle these one at a time. The Cuba, Haiti, Nicaragua, Venezuela, or CHNV parole programs have turmoil right now. So USCIS announced that the parolees would be revoked as of April 24th, 2025. Mickey, can you provide us with information about an update on the status of this program?
Yes. So the announcement by USCIS basically says that the CHNV Parole Program will no longer exist as of April 24th. And the notice was a little unclear about the employment authorization for those individuals because it talks about two ways that the employment authorization attached to the parole program may be terminated. The reference is basically that the employment authorization can be terminated once the underlying reason for such employment authorization, the parole, basically is terminated. And then the notice also says that the employment authorization is terminated once the individual's provided notification of the termination of their employment authorization. And we've received information that some individuals have received notification around March 28th that their parole was being terminated in 15 days unless they challenged the termination and provided appropriate information about why it should not be terminated. And so our understanding is that these notices are being provided to individuals in their My USCIS accounts and that USCIS will continue to provide notifications to individuals going forward. This also creates issues with employment authorization.
Yeah. So for employers, there is this looming question about what to do with the employment authorization for the CHNV parolees. And the employment authorization is, shown via the employment authorization document card. And that references the category C11. So that category C11 also incorporates some other parole programs, but not all employers, retain copies of the documents used for the I-9 verification. And so this creates a dilemma for employers to determine who may potentially lose employment authorization in the near future in order to kind of plan from a business operations perspective. So each employer's situation is a little different, and the strategy should be discussed with counsel. We've talked about it in our committee, and there's just so many different variances and situations that a one size fits all case just doesn't work for CHMB parole. So a lawsuit has been filed about the termination of the CHMV parole program, and we're anxious to see how it is addressed by the court. Hopefully in the next week or so, we should have some information. So moving on from CHNV, another program that had changes last week was the Venezuela Temporary Protected Status, aka TPS. So Mickey, can you let us know what happened with Venezuela TPS?
Yeah. So there's a lawsuit, and on April 2nd, the court postponed the termination of Venezuela TPS as had been ordered by DHS. What that means is that Venezuela TPS returns to where we were with the January 17th redesignation and extension of Venezuela TPS. So for those with TPS that was to expire April 2nd of this year, it has been automatically extended till April 2nd of 2026, so a year from now. Those that hadn't yet submitted an application to register for redesignation can do so now. And those that had filed an I-765 application for new employment authorization document for the TPS, valid until October 2nd, 2026, are eligible for work authorization extension, valid for 540 days beyond the current work authorization, or until October 2nd, 2026, whichever is earlier. So these individuals will need to show their expired or valid EAD card plus the form I-797 receipt notice for their I-765 application in the same category in either A12 or C19. Lots of
Yes.
acronyms,
We
lots of acronyms and lots of numbers and letters.
Exactly, and it gets really confusing, right, with all the is and that's, and it was such a last minute, postponement of the termination of TPS that it has been a little confusing for employers. So thanks for spitting that out, Mickey, and providing some guidance. And so, the judge in this postponement also referenced Haiti TPS. And so we're hoping to hear something about Haiti TPS soon as well. And that currently is scheduled to expire in August. So there's a little bit more wiggle room, so to speak, with Haiti TPS. Also, last week, we started to hear about the visa revocations of F-1 students, as well as the termination of F-1 status, OPT, and STEM OPT for those F-1 students, which receive those notifications via their CVIS accounts, SEDIS accounts for those who follow the F-1 process. So as the week progressed, we kept hearing of more and more CVIS notifications. At last count, well over 500 or more F-1 students have been impacted by this visa revocation and termination of their F-1 in the CVIS account. So, Mickey, can you provide us with an update on what this is all about?
Yeah, so this seems to be pretty unprecedented what's happening now. There are several different categories or types of situations. One is that the revocation of the visa is being conducted by the Department of State, basically invalidating the F1 visa stamp due to an issue like criminal history or status violation issue. And that has always been the case that the State Department can revoke the visa stamps of people that have been convicted of a crime. What's happening now, though, is we're seeing and hearing from people who have minor arrests or charges that were dismissed, and the State Department is revoking those visas. And then in addition to that, the F1 students' CVIS records are being terminated by Immigration and Customs Enforcement. And the students are not really getting notice about it. In fact, what I'm hearing is that schools are not even aware that that's happening until they kind of go in or just checking proactively to look in the students' records. And then they are surprised to see this record terminations.
It is really upsetting, right? There's so much. It kind of happened with one or two that we were hearing about in the beginning of the week, and then it just snowballed into a lot more as the week progressed. So, Nikki, can you tell us a little more about what the underlying reason is for the revocations of the F-1 visas and the F-1 status? I know you referenced, some criminal issues, regardless of whether or not someone's been convicted or even that case has been dismissed, but we're hearing of some other reasons why this is happening as well.
Yeah, and so this unprecedented situation is that, what we're hearing about a lot is F1 students participating in or having participated in protests or forms of speech associated with support for Palestine or Gaza, or speaking out against Israel and actions taken by the Israeli government. The current administration is sort of targeting those F1 students. And essentially, what's being cited for the reason for revocation appears to be violation of an individual's right to free speech under the First Amendment, and calling that action that goes against the US foreign policy interests. And so that basis is being extended to people speaking out and engaging in protest or posting on social media.
And so there's another reason that we're seeing for revocation, as you mentioned, criminal activity. Do you want to talk a little bit about Lake and Riley and how that may have some impact on what's happening with the students?
Sure, yeah. For people that have previously been arrested or convicted of a crime, it may be primarily based on the Lake and Riley Act that was passed by Congress several weeks ago. And what that law does is it mandates the federal detention of undocumented immigrants who are accused of theft, burglary, assaulting a law enforcement officer, and any crime that causes death or serious bodily injury. Its broad provisions could have far reaching consequences for lawful immigrants who reside and work in the US, which is what we may be seeing with F1 students.
So, Mickey, given all this information that you've provided and just an update on what we're seeing, what can these students do at this time? And are they able to seek reinstatement or leave the US or obtain a new visa from a consular post or return to the US? Like, what kind of things should students be thinking about? What are their options?
Yeah, so it really depends on each person's specific situation. We would strongly recommend that each person secure immigration counsel to discuss their specific facts and determine what actions may be possible. It's possible that a lawsuit may be the best option to file a temporary restraining order to block ICE from terminating the CVIS record, but that may not apply to all situations. So, get immigration counsel, see if a lawsuit is the best course of action. If not, weigh the pros and cons of filing to reinstate F1 status, along with whether the individual wants to depart the United States.
Okay. Good information. So, at the spring conferences last Friday, Customs and Border Protection, when they were on the panel, mentioned that emails had been sent to some individuals that are in the US under the United for Ukraine, which we usually refer to as U for U program. And those emails stated that the U for U was being terminated or revoked for that particular individual. Can you provide us with an update on this? Basically, what CBP information they provided to the ALA members?
Yeah, we heard that those emails were sent in error and that individuals that received those emails should now receive emails correcting their mistake. So CBP basically said that at this time, the U4U program has not been revoked. So that was quite a surprise. Kim, what about employment authorization related to Form I-9? Any updates on that front?
Yeah, there's another update on the Form I-9. So last week on April 2nd, USCIS issued a new version of the Form I-9, and that version has a January 20th, 2025 effective date, which is the date of the executive order. The new version of the Form I-9 doesn't have any substantive changes. If you want to think of it from that perspective, there aren't any additional fields that needed to be completed or fields that were removed. But what changes happened is that the term non-citizen national was reverted back to the use of the term alien. And then in the description of some of the documents noted in the list of acceptable documents, references to gender have been replaced by the word sex. For instance, when stating what needs to be included on a document, such as a temporary driver's license that doesn't have a picture attached to it, the list B still does provide, hey, if there's no photo, then the document needs to include X, Y, and Z in order to be accepted for identity purposes. And that's where we've seen the change from the use of the word gender to sex. With respect to when this form needs to be used, essentially immediately for everyone is using the printed version of the Form I-9. And then USCIS did note that web service providers have until May 2026 to update their systems with these changes. So a lot to unpack in the last week that happened and a lot of significant changes that we're seeing. With all of that information, that's a wrap for today's session. Stay tuned for future episodes on updates to the immigration landscape. And if you don't already, please follow our LinkedIn page for WR Immigration, as well as our individual profiles. And we also transcribe each and every episode and post it weekly as a newsletter that you can subscribe to. And the link to subscribe will be in the video description. Until next week, see you later, Mickey.
See you, Kim.